cents, interest at 9.5%, and a writ to issue honor after June the 10th. Next case up, CC 2024-107001, Bridge WF2 AZ Edgewater versus Milton Lasco. Milton Lasco. Not getting a response, courtroom or telephonic appearance. I see service. And notice, counsel, this is immediate.
Yes, Your Honor. The allegation is that on May 10th of this year, the defendant entered into another resident's apartment without consent. He gained entry while he was holding a firearm. Plaintiff alleges that this constitutes crimes, including disorderly conduct and burglary. On a later date, May 15th of this year, he also knocked on another resident's door while displaying the firearm. When the resident answered the door, he simply said never mind and walked away. Again, plaintiff believes this conduct constitutes the crimes of disorderly conduct and threatening and intimidating.
Okay, you have a witness?
Yes, Your Honor. Plaintiff would call Dulce Gutierrez as its witness.
Good morning, Your Honor.
Raise your right hand. Swear or affirm testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Okay, counsel, you may proceed. Have her repeat her name for me.
Could you repeat your name for the record?
Dulce Gutierrez?
And are you the property manager for the Community Peaks on 4th?
That is correct.
And are you familiar with the defendant, in this case, Milton Lasco?
Yes, I do. He is a resident of Peaks on 4.
And does he live in an apartment 271?
That is correct.
Did something happen on May 10th of this year that, along with a subsequent incident, led you to seek an immediate eviction against this defendant?
That is correct. I received a report from a resident from a different unit stating that Mr. Velasco had walked into their unit around 7 in the morning, holding a gun, just walking to the apartment, and they were not unsure of what he needed. And then when they asked him what he needed, he turned around and just walked back home.
And did this resident, how did they know who it was?
There are neighbors next door.
And did they indicate that he was in fact holding the firearm?
That is correct. He was holding the arm up, pointing the gun at the air.
Okay. And then did something else later happen on May 15th involving the defendant and a firearm?
That is correct. I got a report from a second resident down below saying that Mr. Milton walked downstairs, banged on the door around 1:30 in the morning, and then when they opened the door, he just said never mind and walk away.
Did again during this incident, was he holding the firearm?
That is correct. The gun was in his hand.
And it was not in a holster on the side of his on his side?
It was not.
What did the resident say happened after they opened the door?
Mr. Milton just looked confused, look at them, say never mind, and walk away.
All right. Does your lease have a crime-free provision?
That is correct.
And would it require that residents, occupants, and guests refrain from committing crimes?
Yes, it does has that.
All right, I have no further questions.
Okay, counsel, I've just been informed that it's possible the defendant has just appeared in court. Sir that just walked in, who are you? Milton. Milton, have a seat at the table over here. Okay, sir, and go ahead and say your name again.
Milton Lasco.
Okay, counsel for the plaintiff is on telephonic appearance. He does have a witness, and I'll give you the benefit of the doubt, sir. This was set for 10 o'clock this morning, and it is now 10:40, but I'm going to ask counsel to question his witness for their testimony, counsel. Appreciate your patience.
Yes, Your Honor. Ms. Gutierrez, could you introduce yourself one more time and indicate what is your job position?
My name is Dulce Gutierrez. I'm community manager of Pigs on 4th.
Did something happen on May 10th involving a defendant, Milton Lasco, that led you to file a immediate eviction through my office?
That is correct. We had an incident with the neighbor next door, reporting that Mr. Velasco had walked to their door, opened the door, walked into their apartment, holding a gun on his hand, while they were both home around 7 in the morning, the same day.
And according to this resident, he was not invited into the apartment.
That is correct.
And did they indicate that when they confronted him, the defendant ended up leaving?
That is correct.
And could you repeat what occurred on May 15th of this year?
Around 1:30 in the morning, the resident below was awakened by Mr. Velasco banging on the door. When they opened the door, Mr. Velasco looked confused, looked at them, said, "Never mind," and walked away.
And was he holding a firearm during this incident?
That is correct. A gun was on his hand.
And it was not in a holster on his side, he was holding it in his hand?
Correct.
And this happened at 1:30 a.m.?
Around 1:30 a.m., yes.
All right. And you have a crime-free provision in your lease agreement?
That is correct.
And does that apply equally to residents, guests, and occupants?
That is correct.
And so if a crime is committed on community grounds, that would be in breach of the lease?
That is correct.
I have no further questions for my witness.
Hey, Mr. Lasco, do you have any questions for this witness?
What witness? She's not there. She wasn't there.
That's not what we're disputing right now. She's the property manager. She's got.
Not the witness.
Ma'am, sir, sir, do not argue with me.
Okay.
Do you have any questions for this witness?
She's not the witness.
So you have no questions for this witness?
She's not the witness.
You have no questions. Counsel, any other witnesses?
The two
Sir, I'm asking you, do not argue with me.
I'm not arguing.
Yes, you are. You'll have an opportunity to testify. I asked you if you had any questions.
No.
That's the only issue
Not the witness.
right now. Don't repeat, sir.
The occupants are the
Don't
witness.
repeat.
The occupants.
Don't repeat. You'll have an opportunity to testify. I asked you specifically if you had questions for this witness. Counsel, any other witness?
No other witnesses?
Okay. Rest, counsel?
Yes.
Sir, did you wish to testify and tell the court your side?
Of course.
Raise your right hand. Swear or affirm testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
May proceed, sir.
Okay. She wasn't there. Where are the occupants?
Sir, you want to tell the court anything about the allegations, sir? Are you going to tell the court anything about the allegations or not?
Yeah, I want to hear. Let's talk to the occupants.
Sir,
That's
this is
second
your,
hand.
this is
Listen
your,
to me.
no, sir.
You asked
Sir,
me, if I had something to say.
And you need to address the complaint, sir.
That's what I'm trying to do.
Go ahead.
The occupants in both those apartments, let's talk to them. Not her in the office.
So, sir, are you saying you don't wish to respond to the immediate complaint that was served on you?
I don't understand that.
The complaint that's something occurred on May 10th and May 15th, you don't want to respond to that.
I don't understand. I don't want to, I just did. Let's talk to the occupants.
No, so you have no response to it whatsoever.
I just did. Let's talk to the occupants, not
Sir,
to the office manager.
this is your opportunity.
Listen,
If you want them as a witness, you would have
neither
brought
one
them
of
in,
them
sir.
filed the complaint. Neither one of them filed the complaint.
So, sir, you're not responding to the plaintiff's complaint about an immediate eviction.
She got all this secondhand information from an apartment across the street.
So you don't want to tell the court what happened.
I just did.
So you haven't told the court what happened, sir. Is it you don't wish to tell the court what happened?
I'm saying let's hear it from the tenants. Not some people across the street heard it secondhand and called the office. And she got it that way, not from the tenants. Okay?
Okay, so you don't want to tell the court what happened on the 10th of May or 15th.
What happened, okay? I can tell you right now, downstairs, the bottom apartment, I never displayed a firearm. She said I did. I never did. I never displayed a firearm. Okay, it's my word against hers. Ask the tenants.
Is that all you want to tell the court then, sir?
I just did.
I'm asking you, is that all you want to tell the court?
That's for that apartment. Now you talk to the tenant upstairs. He didn't file no complaint. Okay, I raise my hand. I'm telling you the truth. Get him in here and both of them, let them tell the truth. She got some secondhand information from an apartment ripper, somebody who's ripping the rent across the street.
Okay, anything else, sir?
That's it.
Counsel, any cross?
So you're not denying that you entered the next door apartment while holding a firearm?
I never said that. I'm saying talk to him and ask him.
Okay, so, but you're not going to deny it under oath? I have no further questions, Your Honor.
Okay, sir, no other witness for you?
Me? No.
Okay, very good. Counsel, any rebuttal?
No rebuttal, Your Honor.
Closing?
Yes, Your Honor, I believe that the plaintiff has met its burden of preponderance of the evidence. It is a crime in the state of Arizona to recklessly display a firearm. The defendant in this case, I'm not quite sure what is motivating him to do these things, to enter his neighbor's apartment in the morning with the gun, or to show up at the other neighbors while holding a gun. In both instances, the resident indicated that the defendant appeared to be confused. And perhaps that's the case, that the defendant was not, didn't have any malice intent. But the fact of the matter, if he's confused, he can't be wandering around while holding a firearm. Again, the testimony in both instances was not that the firearm was in a holster on his side, as would be, safe and proper, but that he was holding it while confused. Plaintiff would assert that this would constitute the crime of disorderly conduct, the elements of which are that the defendant recklessly displayed a firearm. The defendant was holding a firearm during two different incidents involving two separate residents while he was confused. That would be a reckless act. It would be a dangerous act. And therefore, we would ask for immediate possession of the property. And I see the total monetary award is incorrect on the judgment. It should just be court costs and attorney's fees for a total of $304,000. $318. So we would ask for that as well. As the final thing that I would point out is that the defendant, given the opportunity to testify, he did testify. He denied the incident on May 15th, but he did not deny the incident on May 10th. Thank you.
Thank you. Sir, you're allowed an opportunity for a brief closing argument. Essentially, it's a summary of why you think the court should or should not grant this judgment. Mr. Lasco? Do you have a closing statement? Closing argument is, again, it's just a summary of why you think the court should or should not grant a judgment against you. Sir? Mr. Lasco? Do I need to get urgent care in here, sir, for you? Is there a problem? Are you need help? Need of help? Medical assistance? Mr. Lasco?
No.
Okay. Very well then. Plaintiff has met its burden of proof. This is a civil matter that only requires preponderance of the evidence. I do find for the plaintiff, I'm granting that judgment of $318. Writ of restitution can be issued on or after the 25th. Sir, the court's not open on the weekends, so that means in reality, first thing Monday morning, they can get the constable to come out and lock you out, unless you have some written agreement with the landlord to stay any longer. Please go back around the corner to window 5, and they'll give you a copy of this judgment. If you're planning on staying longer, you need to have some agreement with the landlord. Good luck, sir. Next case up, CC 2024-107003. Carrie WWC Newport owner versus Takia Prince and Alexis Haywood. Takia Prince, Alexis